Supreme Court, and the Supreme Court ruled that the protections under 167 CRPC and Section 19 of PMLA, which relate to recording of the reasons for arrest and then furnishing them to the accused in writing, are essential. And without that, the arrestee can seek release, and he can be released on those grounds. Do you think this could give many people who are facing Enforcement Directorate investigations a chance to go to court? There may be more cases like this?
Absolutely right. I think the Supreme Court has given a path-breaking judgment because what was happening in the country is that although under Section 19, it was important for the arresting officer to communicate the reasons, but those reasons were not necessarily given in writing. So we had a situation where in some cases they were being made to read out the grounds of arrest. In other cases, they were being told the grounds of arrest. In some cases, they were being given copies of the ground of arrest, but the ED was not following a uniform practice in the entire country, which led to the Supreme Court to pass this path-breaking judgment to say that it is not sufficient for the Enforcement Directorate or the officer or the arresting person to actually only communicate orally or make the person read the grounds, because he may not be in a state in order to comprehend the gravity of the offenses, and it would not be fair, because what is required is that the person who's arrested has to be produced before the magistrate, and thereafter he has to basically prove himself that he is not guilty of the offense, and the magistrate has to be convinced, based on the plea of the lawyer of the arrestee, that he's not going to be likely to commit another offense. Now, in order to safeguard all of these rights, which the Supreme Court has been saying it since many, many decades, the Supreme Court thought it fit that rather giving it a very vague flavor that only the person being arrested needs to be informed, it is but natural that he needs to be given all this in writing so he is able to make out his case, a foolproof case, in order to put it up into the best possible way of getting his bail. That's one reason. The second is that in any event, the officer is required to submit all of this to the adjudicating authority. Now, if these grounds are already in writing, there was no reason why the person who was getting arrested were not giving these grounds. So the Supreme Court said that these need to be given in order to uphold the sanctity of justice and to give an opportunity for the person to go and apply for bail.
Right. Mr. Ranina, do you think the Supreme Court has only upheld or clarified what the law already says, or they've read this into the statute?
No, they have clarified the law, because the law is very clear, and they have only said that the law must be upheld in letter and spirit. And therefore, they have made it very clear, because as was rightly pointed out by my colleague, in the past, different officers were adopting different stands. They were not complying with the law. They would just read out the charges, or they would just give them a vague idea of what the charges are. And this has to be put down. You cannot those who enforce the law cannot be above the law. They have to strictly follow the law of the land. And this is what the Supreme Court has now emphasized. Right. Every single officer in every part of India will have to obey the law of the land and make sure that it is complied in letter and spirit. And therefore, written summons or written explanation must be given, the cause for the arrest, what offense he has committed, what evidence they have in their possession. All that needs to be disclosed so that the arrestee can defend himself before the magistrate when he applies for bail.
Right. All right. Farid Karachiwala, one very important case issue that came up before the Supreme Court, and the Supreme Court has ruled that this shows a lack of bona fide, and they referred to how the original ECIR in this case was registered in 2021. The accused was summoned in connection with this case. The accused sought anticipatory bail, and this was given to them till the next day. Then the accused were called the next day, summoned in connection with the old case, and that same day they were arrested in connection with a second FIR. So called on one pretext, arrested on another, all within a span of 24 hours. What does this show about the working of the Enforcement Directorate, and what would they have to change from here?
So the Supreme Court has made it in no uncertain terms. Paragraph 20 actually of the Supreme Court judgment makes it very clear that there needs to be a very high level of fairness because the authority and the power that the Enforcement Directorate has is very, very vast, and they need to exercise it fairly without any arbitrariness. There shouldn't be any colorable exercise of powers, and they need to be above board in respect of preventing any kind of miscarriage of justice, particularly because the powers which they exercise under the PMLA is, to that extent, if I may say so, a little draconian, where under Section 45, it is basically for the accused to prove himself that he's not guilty of the offense or that he's not going to commit any other offense. So to that extent, the Supreme Court has made it very clear that this exercise of power needs to be above board, needs to be fair. There shouldn't be any colorable exercise of power. There shouldn't be any vindictiveness, and the authorities need to actually act in a manner which would withhold or which would, show that the authority which is being exercised is without any real, damage which is done to personal liberties.
Mr. Ranina, do you feel that this entire judgment will make the working of the Enforcement Directorate, their approach to interrogating, summoning and arresting accused, more transparent?
I think so, and I think it needs to be so, because not only it has to be transparent, but it has to be fair, and everybody must be given an opportunity to be heard and to give his point of view. So if everything is in writing, then alone a person can deal with the issues. If something is just told to you orally, I mean, it can be very vague. But if something is in writing, you can pin down the Enforcement Directorate and find out what exactly is the ground for the arrest, or in what way the person has violated the law. And only then can a person defend himself in a court of law. Therefore, the important point is the written statement should be forwarded to the arrestee before any action is taken against him.
Right. And finally, why do you think this is important, Farid Karachiwala? Because the court also said that if you do not give the grounds of arrest in writing, then the accused does not know why he's being arrested. And this can lead to a bit of confusion when the case is also before the court. Why do you think this is important, and why was it important for the Enforcement Directorate to do this?
So in the present case, which the Supreme Court has decided in the matter of Pankaj Bansal and Basan Bansal, the question was, Basan Bansal, who could not read English, was given, the grounds of his arrest orally in English. He could not understand English. He in fact, his plea in the Supreme Court was that he was never even told about it. The arresting officer made out a case that this was not only told to him in English, but it was also told to him in Hindi, and it was also told in the presence of witnesses who had signed the statement which said that these grounds were made known. But when Basant Bansal, made his plea before the court, his plea was that this was never informed to him. Now, what the Supreme Court said, that if you look at the totality of things, if there are grounds which are there in writing, and if these grounds have to be submitted to the adjudicating authority in writing in a sealed envelope, then why isn't it being made known to the arrestee so that he knows what kind of a case he needs to deal with when he applies for bail? Under Section 45, it is for him to show that he's not guilty of an offense and that he's not going to commit any other offense.
Right.
Now, if these grounds are to be communicated to him clearly, he will be able to make a case in order to show as to what is it that he has done or has not done in order to secure bail. So the Supreme Court said that in the totality of things, it is but necessary, and there's no reason why these grounds shouldn't be given in writing.
All right. Thank you very much, Farid Karachiwala. and also HP Ranina for joining us on the program. Let's move on. One of the oldest semiconductor assembly and packaging plants in India, CDL Semiconductors, is all set to increase production by 100 million units. CNBC-TV18's Abhimanyu Sharma visited the company's Mohali facility and reports that the company has also begun producing silicon carbide semiconductor devices, which are extensively used in electric vehicles, solar inverters and industrial motors.
CDL Semiconductors has become the first Indian company to start the production of silicon carbide devices. With the launch of a new packaging line of surface mount semiconductors, the company aims to raise its annual production capacity to 600 million units. The additional 100 million units per annum capacity is just the beginning. The company wants to increase production of semiconductor devices for use in sectors like automobiles, defense and aerospace, telecom, consumer electronics and IT. CDL believes there will be a huge demand uptick for chips for electric vehicles, power management devices and also solar panels, and wants to get a first mover advantage.
FX scheme of Government of India provided a contribution in this scheme also. This is a 3-phase scheme, and today we have seen the first phase completion, and second and third phase will be completed in next 12 to 18 months time. We are receiving applications. So because of confidentiality, we cannot take the names of the proposals, but we have received 5 proposals also. We have received compound semiconductor and packaging proposals also. Right now we are evaluating the announcement you have seen in the recent past, starting from Micron, AMD, Applied Material, Lam Research, Microchip, and then agreement signed between India and US and India and Japan. And there are many more collaborations are all on the way. So these developments are giving us clear-cut signal that India is going to become a very, very important player in semiconductor and entire GVC.
Despite the government's push, there is a dearth of indigenous production in this space. But CDL is looking beyond domestic demand and wants its products to conform to international standards to cater to a global market.
This is a fundamental sector and is a building block for a vast spectrum of industries, and that it's like a meta resource, the electronics manufacturing. Micron's signing was the first, and I think it's the first of many to come. This semiconductor business is indeed a global industry. There is no country in the world that does everything from start to end. Everybody is interdependent on each other.
CDL has also signed an MOU with the Semiconductor Laboratory under the Ministry of Electronics and IT to benefit from government's R&D. The company feels the Indian semiconductor industry will need government support for at least 10 years, so a strong foundation can be laid. Currently, most wafers and other materials used in semiconductors are imported due to lack of an ecosystem in India. With signing of an MOU with SCL, CDL Semiconductors is looking to manufacture wafers in India in the next few years, like the ones used in this semiconductor component. In Mohali, with video journalist Akhilesh Kumar Verma, this is Abhimanyu Sharma for CNBC TV18.
All right, thanks Abhimanyu for getting us that report from Mohali on CDIL's semiconductor unit. Time for a short break here on NewsCentre, but coming up, Petroleum Minister Hardeep Singh Puri warns of organised chaos if oil prices breach the $100 mark. Details when we are back.